Welcome back. You certainly possessed what it takes to advance this far, at least a notch above the rest. Do you want to play another game? After analyzing the presented informational facts, you, as a leader, will be tasked to render an executive decision on what actions to take, based upon the best available evidence. Do you have what it takes? Do you have the right stuff? Are you ready to be all you can be? After January 6, 2021, most are probably familiar with a legal term of art, which had, before that time, been the topic of a legal brief presented to the U.S. District Court for the Eastern District of Virginia in 2019. It is of note that, although 1,575 people were charged in connection with the January 6th attack at the Capitol, in an event in which the FBI has estimated that around 2,000 people took part, all but 14 of about 1,270 convicted rioters, but mostly on charges of obstruction of justice and other offenses, but none, technically, despite the popular term, expressly for what legal professionals, prosecutors and courts would describe, quite properly, as insurrection. Under 18 U.S. Code Section 2383, whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. The operative words here, for the actus reus, or criminal act, involves an incitement, an instigation, a rendering of assistance or engagement in a rebellion against either directly the United States or its laws. Whoever commits an offense against the United States or aids, abets, counsels, commands, induces or procures its commission, is punishable as a principle. Whoever willfully causes an act to be done which if directly performed by him or another would be an offense against the United States, is punishable as a principle. Rather quite a serious affair. And, like any criminal or even tortious act, there must be a victim to be injured, which in this case, could simply be the laws of the United States, a question once again being raised now in both state and federal courts. Ignorance of a fact may sometimes be taken as evidence of a want of criminal intent, but not ignorance of the law. And, as a matter of fact, in a court-directed argument, it can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned, that we were hit with a virus that was met with silence and spread unchecked, emails for days, weeks, then months that led to more deaths, more infections, more stress, and more loneliness. It can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned that on January 21, 2020, the first confirmed case of COVID-19 in the United States was diagnosed. Those are simply the facts and nothing but the facts. And, to the extent that for every action, in a public health crisis, in the government, there is an equal and opposite reaction, as early as January 4, 2020, according to the Veterans Administration, the Office of Emergency Management notified Veterans Health Administration, VHA, senior leadership and began tracking a pneumonia of unknown origin with 40 cases surfacing in China. And, on January 31st, Defendant Azar, the Secretary of Defendant U.S. Department of Health and Human Services, declared a public health emergency in response to COVID-19 pursuant to the Public Health Service Act. So, following this series of events, for review, we had some matter of great significance in public health, for which, as early as January 4, 2020, departments within the federal government had commenced an initiative to monitor developing events, and by January 31, 2020, the executive departments under the Office of the President had taken some action, declaring what has been described as an emergency under the Public Health Service Act. Written messages are not communicated unless they are read, and reading requires an affirmative act. In a rule of law, no power can be exerted unless it be found in some express delegation of power or in some power to be properly implied therefrom, and, while for most laymen, everything appears quite copacetic if we had a public health crisis and the HHS secretary had declared an emergency, in a courtroom the details sometimes go further than that, and in matters now before both state and federal courts, elected and appointed leaders are being asked whether that declaration of an emergency on January 31, 2020, under the Public Health Service Act, as an authorizing provision, had anything at all to do with the draconian measures that had later been implemented by both state and federal governments. And the focus here, and now, is upon another declaration of an emergency under the laws of the United States, which would not occur until 4 days later, when, on February 4, 2020, pursuant to Section 564 of the FDNC Act, he had determined that there is a public health emergency that has a significant potential to affect national security or the health and security of United States citizens living abroad, and that involves a novel, new coronavirus, nCoV, first detected in Wuhan City, Hubei Province, China in 2019 nCoV, and had declared that circumstances exist justifying the authorization of emergency use of in vitro diagnostics for detection and or diagnosis of the novel coronavirus 2019 nCoV, pursuant to Section 564 of the FDNC Act, subject to the terms of any authorization issued under that section. Not under the Public Health Service Act, which expressly pertains to members of the Public Health Service, but rather under the FDNC Act, or Food, Drug and Cosmetics Act, the Health and Human Services Secretary had declared an emergency under an amendment to that enactment that had been passed by Congress under the Bush administration in 2003. However, as the Health and Human Services Secretary had promulgated in the Code of Federal Regulations on February 4, 2020, that emergency had only pertained to those citizens who were residing, and not just traveling abroad, which would include over 75,000 employees of the State Department and over 30,000 military dependents. And it had also pertained only to what had been expressly described as national security, which, for these purposes, would be limited to those over 2 million members of the uniformed services on active duty, as well as the reserve components and National Guard. And the first problem that arises, upon retrospective examination, is that on February 4, 2020, none of those persons had been infected by a novel, new coronavirus, nCoV, first detected in Wuhan City, Hubei Province, China in 2019 nCoV. The virus is now named SARS-CoV-2, which causes the illness COVID-19. Under the law, an agency bears the initial burden of proving feasibility based on the best available evidence, and substantial evidence must be introduced to support the finding, and agencies possess a duty to present and explain its evidence and the analysis which led it to find the standard feasible for an industry. Under the law, it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, and, if those grounds are inadequate, a court may remand for the agency to offer a fuller explanation of the agency's reasoning at the time of the agency action. The traditional rule dictates that ignorance of the law is no excuse, knowledge that the conduct is unlawful is all that is required. Under 18 U.S. Code Section 2383, whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. Based upon the best available evidence, would you have wakened the president? Truth or consequences? Did you wake the president? This concludes this simulation, and you shall be contacted with the results. Thanks for your participation. That is all. Carry on.
This message was approved by Major Mike Webb.